Hello and welcome to another episode of Ezoic Explains. I'm Whitney Wright, and today I'm going to be going over the CCPA, what it is, how it's different than GDPR, and how it affects and applies to publishers around the globe. So a recent Pew study showed that 6 out of 10 Americans don't believe it's possible to go through their daily lives without their data being collected, either by a company or the government. Last year, I attended Adweek New York, and I went to this panel that discussed generational differences about data privacy and collection. The younger generations, such as Gen Z and millennials, they kind of saw it as a caveat to using the internet. They assume their data is being collected all the time and that there's really nothing that they can do about it. It's just part of life. Whereas some of those older generations, like Gen X and baby boomers, they were more concerned with their data being collected, how it's being used. They didn't really like people watching them, were wary of voice commands and such. So in response to this growing concern, privacy laws have been created or in the works. GDPR has been around for a few years, and then not surprisingly, California went along and created their own as well. And there are actually some other states that have something similar in the works or are already enacted. California passed the California Consumer Privacy Act in June 2018. It's similar to GDPR, similar sentiment, but a bit of a different execution. Many people see these laws as reactive, especially to large data protection misuses. You have Cambridge Analytica, the Snowden issue in 2013, while others see it as proactive, though most of these things end up being a figure it out as we go thing. The internet has never really regulated something like this before. It's kind of just been free in the Wild West since the beginning, and unfortunately now we're having to backtrack a bit with this stuff. So let's break these two acts down and see how they are similar and different. GDPR, in a nutshell, gives internet users greater control over their privacy and has been around since 2018, implemented by the EU. The complete guidelines to GDPR and how to be compliant has been a bit of a mess since it was first created. A lot of users, publishers, advertisers, people in the space still aren't completely sure how to do it all correctly. Especially when this began, there were tons of companies that weren't GDPR compliant, and quite a few of them got big fines. As part of GDPR, web browsers display the cookie notice to users that reside within the 28 countries that make up the EU. GDPR requires that data collectors must obtain end users' consent for the use of cookies or other local storage where legally required, and the collection, sharing, and use of personal data for personalization of ads. When that consent is sought, you must retain the records of consent given by end users and provide end users with clear instructions on how to revoke consent. It's just giving a lot of power back to consumers, how to revoke that kind of consent when their data is being collected. Companies have to retain the records of consent. The American Enterprise Institute came out with a study in March of 2019 with the top 10 problems of GDPR. I'm sure there's lots of others, big and small, but some of the ones that they pointed out were it strengthens the largest players, increases cybersecurity risk, identity theft and fraud, and that it has overall not created greater trust online. As for the California Consumer Privacy Act, it began January 1st of this year, 2020. Like GDPR, it dictates requirements for identifying, managing, securing, tracking, producing, and deleting consumer privacy information. The CCPA applies if you're a for-profit business that collects and controls California residents' personal information, if you do business in the state of California, and if you have an annual gross revenue in excess of $25 million US dollars, and you meet one of the following requirements. Either you receive or disclose the personal information of 50,000 or more California residents, households, or devices on an annual basis, or you derive 50% or more of your annual revenue from selling California residents' personal information. Some exemptions from the CCPA include organizations such as small companies that do not meet any of the 3 requirements in the section above, public agencies, nonprofit organizations, any information collected while conducting business that takes place outside of California, hence California Consumer Privacy Act, and any entity that controls or is controlled by a covered CCPA applicable business or shares common branding with a covered business, such as the shared name, service mark, or trademark. There are 5 general CCPA amendments that California refers to as rights. This includes to know what personal information is collected about users, to know whether and to whom the personal information is sold or disclosed, and you can opt out of that sale. Users can access the personal information that has been collected. They can request that a business delete their personal information, and no one will be discriminated against for exercising their rights under the Act. For businesses that want to be CCPA compliant, you must create a privacy notice, and they are the same user rights within the CCPA amendments. There are some differences between the two, actually quite a few, even though they kind of mean and do the same thing. GDPR requires consumers to opt in for the use or sale of their personal data with pop-ups that you've likely seen across the internet. The CCPA does not require consumers to opt in for the sale, but it does require specific privacy notices as well as providing the right to opt out or use of personal information. So the difference here is that GDPR requires consumers to say, yes, you can sell my data. And this has to be a pop-up, whereas the CCPA does not require consumers to opt in, but it gives them the option to opt out. GDPR applies to all businesses that process data, no matter the business location or size. It's to all businesses that collect data and process data. CCPA only applies to California businesses with revenue exceeding $25 million US dollars, or those businesses whose main purpose is the sale of personal information, like Cambridge Analytica. CCPA doesn't require that businesses have a specific person dedicated to data protection or that they require impact assessments. GDPR requires that there is a data protection officer and that assessments are made. And California residents also only have access to the data that was collected on them within the last 12 months. The CCPA also has different definitions for what personal data technically means. Versus GDPR. CCPA also requires that consumers have an absolute right to opt out of the sale of their data, and businesses must have a do not sell my personal information link on websites and mobiles. That's just reiterating that CCPA can collect your data and sell it as long as you don't click the do not sell my personal information link on websites and mobile, whereas GDPR requires that you opt in to allow businesses to collect and sell your data. Additionally, while both require that certain provisions be included in contracts with service providers, the requirements differ, and it's likely that GDPR would not satisfy CCPA and vice versa. And then privacy regulations regarding children also differ. The financial punishment for noncompliance, they're both a little bit different as well. GDPR fines for not following the rules, they can either be 20 million euros or 4% of the company's annual global turnover. Whichever is greater, and this is where you see how France sued Google for $57 million, even though the fine is up to 20 million euros. CCPA fines are also applied per violation, and those violations are $2,500 for unintentional and $7,500 for intentional violations. In the US, $100 to $750 per incident per consumer or actual damages, if higher, for damage caused by a data breach. And as currently written, the law states that businesses shall only be in violation of the CCPA if it fails to cure any alleged violation of the CCPA within 30 days after being notified by alleged noncompliance. If you have 30 days basically to fix your mistakes, then you will not be in violation. GDPR is not as friendly. CCPA only fines companies when there's an actual breach, whereas GDPR can fine businesses when there is a risk of breach and a responsibility. Additionally, individual persons can sue businesses with CCPA. GDPR also only focuses on data concerning EU consumers or citizens, while the CCPA includes consumers and households. CCPA also sometimes only applies to data directly taken from the consumer, but this does not regulate data taken from third parties. So, as a publisher, what does this all mean for you? First, there are 2 questions you need to ask yourself regarding whether you have to even comply with CCPA. And these 2 questions are, do any of the conditions in Section 3 apply to me? Do any of the exemptions in Section 4 apply to me? So if you go back and you look at those requirements, if you make over a certain amount of money, or if you're exempted, such as nonprofits, if the answer is no to Section 3 or yes to Section 4, then you do not have to worry about complying with the CCPA. which is a big relief for probably a lot of publishers. However, even if the CCPA doesn't apply to you, you should be aware of what it includes, especially if you are working with third parties. The way some third parties operate could be non-compliant to CCPA, which would then put you in danger of non-compliance. So be sure to double check all the fine print with any third parties you're partnering with to make sure that they are CCPA compliant. There are a lot of great tools and resources out there to help with both GDPR and CCPA, including items from Google and Ezoic. Ezoic actually has a compliance management tool, and Google has all sorts of resources. And that's it for this episode of Ezoic Explains. Thanks so much for listening. If you liked what you heard, please subscribe to our channel. Please subscribe to this playlist. We have a bunch of other playlists on our channel. You can find us on Twitter, YouTube, Facebook, LinkedIn, or at ezoic.com. All of the links to what I was discussing will be below, and there is a link to the blog where a lot of the resources can be found that I discussed earlier. This has been another episode of Ezoic Explains.